Good evening. Justice Sri Muralidhar garu, Justice J.Chelameswar garu, Dr. Devesh Nigam, Registrar of University of Hyderabad, members of the Alladi Memorial Trust, colleagues, students, and esteemed guests from outside the university, good evening and welcome to the Alladi Memorial Lecture on different yesterdays for a different tomorrow, the what if moments in Indian constitutional history. I extend this welcome on behalf of School of Social Sciences. We at the school are very happy to collaborate with the Alladi Memorial Trust, and this collaboration goes a long way. It started in 2011 when we started hosting Alladi Memorial Trust lecture on behalf of the Center for Human Rights, School of Social Sciences. We consider it an honor to be hosting this lecture, and particularly a privilege to have a lecture by two stalwarts today who have inspired individuals and institutions with their thoughts and phenomenal judgments. Please give me a minute to introduce the School of Social Sciences. The School of Social Sciences is multidisciplinary and interdisciplinary in nature, with 13 academic units, some actively functioning and some silently inspiring us with their work. And the school has always been a platform for exchange, sharing, and debating of ideas, this being one such occasion. May I request the chair, Sri J.Chelameswar garu, and the speaker, Muralidhar garu, to come onto the dais, please. I request Dr. Ashley from St. Stephen's, Delhi, to hand over the bouquets to the chair and the speaker. It's my pleasant duty to introduce the chair before I request him to conduct the proceedings. Justice J.Chelameswar garu served as Judge, High Court of Andhra Pradesh, Chief Justice of Guwahati and Kerala High Courts before being elevated as Judge, Supreme Court of India in 2011. He retired in June 2018. He is known for his integrity and his ability to speak his mind openly and courageously. Among his most outstanding judgments is the freedom of speech, where he, with Justice Rohinton Fali Nariman, struck down a controversial law which gave Indian police the power to arrest anyone accused of posting emails or other electronic messages which cause annoyance or inconvenience. The judges clarified that a distinction needs to be made between discussion, advocacy, and incitement. He was a member of the 9-judge bench dealing with Aadhaar, which held that there is a fundamental right of privacy under the Constitution. He delivered a separate and conquering opinion, much acclaimed in the academic circles. In his dissenting opinion in the National Judicial Appointments Commission verdict, Justice J.Chelameswar had criticized the collegium system of appointing judges, which he said has become a euphemism for nepotism, where mediocrity or even less is promoted and a constitutional disorder does not look distant. Sir, I request you to conduct the proceedings, please. Thank you so much.
The next item is a little embarrassing. Anyway, I have to read it out. Honoring the chair and speaker. No, but then she asked me to conduct the meeting. What do I do? Hmm. Then next item is Professor Alladi Uma, Chairperson, Amma Memorial Trust, introduced the Trust and Justice Muralidhar, the Speaker. Where is she?
Good evening to all here. It gives me great pleasure to be once again in the University of Hyderabad, where I taught for many years and where we started the collaboration. And I'm particularly happy to collaborate with the School of Social Sciences and the Dean School of Social Sciences, who worked with me in the English department and is a very dear friend. I'm thankful to Justice J.Chelameswar Garu and Justice Muralidhar for accepting our invitation so readily. Sunita has given a very formal introduction, and I may fail in my duty because I'm not going to be that formal. So please forgive my lapses and other kinds of things. What does one say of Justice Muralidhar? When I told somebody, one of my very close friends, that Justice Muralidhar was going to speak would speak and give the Alladi Memorial Lecture, she said, "Oh, he speaks. He's a much, person who speaks a lot. Should I take it as a compliment, or what was she saying?" But I would turn around the language of the judges and say this in a positive manner, as we in literature have the liberty to do, that he's a most wanted man. Okay? Before I say anything much more about Justice Muralidhar, let me take a few minutes. I won't take too much of a time because many of you may think, including Soumya here, who may think that I've retired so long ago, I want to hold forth on the mic and give a talk. The Alladi Memorial Trust was founded in 1983 by my late father, Justice Alladi Kuppuswamy, who retired as the Chief Justice of Andhra Pradesh, and in memory of his father, the late Dr. Alladi Krishnaswamy, who was one of the members of the drafting committee of the Constitution. His idea was that to remember his father is to remember the Constitution. To remember the Constitution is to take the principles, the democratic principles, the socialistic principles of the Constitution to the public. And so he decided that we should have a lecture every year around 3rd October. Actually, his birthday is in May, but May is so hot in Hyderabad. And October 3rd was my grandfather's death anniversary. So we thought that any date that is close to October 3rd would be the right time to have the lecture. The lecture, the first lecture, I will mention only the first lecture because such wonderful talks have happened, and if some of you are interested, we have brought out 2 volumes, and those 2 volumes are available outside. And we have had a gamut of speakers, including Justice J.Chelameswar here. And the first lecture was given by Justice Hidayatullah, the then Vice President. Actually, he did not give the lecture because he was the Vice President of India, but as a lawyer who respected Alladi Krishnaswamy, he came forth to deliver the lecture. Unfortunately, I missed the lecture, but I'm told, I read the lecture and you attended it. And I think Sitaram must have attended the lecture. No, I think we were both away in the US, and so we didn't attend the lecture. Sitaram is my brother. And after that, we have had judges, retired judges. One of the things my father wanted was, so we waited for you, Justice Muralidhar, to retire, was that we should not ask anybody in office to deliver the lecture because we put them in a spot. And therefore, we have never invited sitting judges of the High Court or the Supreme Court. And we've had academicians, political scientists, journalists, and social activists. We've had a whole number of people. We have had from women, we've had men, we have had Dalits, we have had different things. I'm sorry we have never had a transgender, and maybe we will set it right soon, who could talk about the rights of transgenders. We did have a seminar where this was talked about. So we've had this over the years, and then we used to conduct it in the city. But then my father felt, well, 30 years ago, I was not that old, but most of the audience were what I am today. So he said, I'm not having this lecture to deliver it to audience of that age. We can't convert them. So let us go to the university. And so I was at the university, and I approached Professor Hargopal, who was then involved with the Human Rights Center, who put us on here. And ever since 2011, every year we've had the Alladi Memorial Lecture. There's also an endowment by my maternal grandmother in the name of her husband, Uma Maheshwaram, Justice Uma Maheshwaram, who was a judge of the Andhra Pradesh High Court, and he was interested in law and religion. So we've had occasional lecture series on law and religion as well. This is about the legal part of the trust. We also have educational and health programs associated with the trust. And I find that one of our associates from NICE, Rakhi, I thought I saw him here, NICE Hospital with whom we work, where we have adopted 19 government schools, and they take care of the health programs in those 19 government schools. We help educational institutions, and there are two people from Spandana we respond who are also on our advisory board, Manohar and C.K. Babu. C.K. Babu has gone? Okay, who run this non-profit organization, and so they help us with the thing. After my father passed away, I was happy to take over as chair of the thing, and we are a small trust board consisting of myself, my brother Alladi Sitaram, who retired as professor of of mathematics in the Indian Statistical Institute, and Professor Sridhar, who took voluntary retirement from the University of Hyderabad, from the Department of English. So we are, though Sunita said this is a collaboration between University of Hyderabad and Alladi Memorial Trust, I consider myself part of the university and also part of the trust. So I have a double-edged thing here. So with these few words about the trust, let me go on. I don't know where to begin about Justice Muralidhar. I mean, he has such a brilliant academic career. All of you must have read the introduction in the invitation we sent you, so I'm not going to talk about that. But I'm amazed how he could combine academics with the work he had at court as a very busy lawyer. While he was practicing, he also earned a degree, PhD degree in criminal law from the University of Delhi, okay? It's not a conferred degree as many of us think, but it's a degree that he did on criminal law, if I'm not wrong. And he worked as a lawyer, and one of the cases that I think, I was reading a poem by Rudyard Kipling called If, in which it says that when you move along with men, and that's what Justice Muralidhar does, he moves along with men, while at the same time he has a sense of himself. And this is best reflected in the case he argued after his retirement for people, prisoners, where he talked about the caste system there, and that brought about a big reform in the thing. It says that he moves along with what they call kings in that poem, but what I would say, the people of upper standing. But he has such integrity that one cannot question how it was. So I think it was this honesty and integrity that made him be elevated from being a judge to the Chief Justice of Orissa High Court. He retired as the Chief Justice of Orissa High Court. And I can't keep on talking about him because what we have come here is not to hear Uma's voice. I understand the word Uma also means, no, I shall not speak anymore. That's the word that is supposed to mean. So I shall stop here and I will let the chair proceed. Thank you all very much for coming once again. Thank you so much.
The next item in the program is the chair's remarks. I have the good fortune of being associated with the series of lectures starting from the first lecture delivered by the then Vice President Hidayatullah. I distinctly remember that lecture took place in the Bharati Vijay Bhavan hall next to the Nizam College, somewhere in that lane. Apart from that, I have a long association with Justice Kuppuswamy and his family. Personally, from 1984, by proxy from 1922. My maternal grandfather and Uma's maternal grandfather were class fellows in the Madras Law College, Justice Uma Mahesh. So, personal note apart, I had a long association. After retirement, when Justice Kuppuswamy decided to write a biography of his father, and also he was called upon by the publisher to edit Mayans Hindu Law. He needed some assistance. He called one of his former juniors, late Mr. Venkataramanaya, who eventually became the Advocate General of Andhra Pradesh, and I was his associate as Additional Advocate General when he became the Advocate General a second time. So Justice Kuppuswamy had called Mr. Venkataramanaya and asked him, can you ask him whether he could suggest some couple of youngsters to assist him in this project. My friend Justice Raghuram, who is a direct junior of Justice Venkataramanaya, Mr. Venkataramanaya, Mr. Venkataramanaya naturally chose Raghu, not because he was junior, but Raghu is otherwise I'm sure most of you must be knowing, an outstanding lawyer and a judge. And it so happened, Mr. Venkataramanaya suggested my name, the second name. So that's how it all started after retirement, after Justice Kuppuswamy's retirement. I spent countless evenings with him, working, gossiping in between naturally, and then sharing fine dosas and coffee at Justice Kuppuswamy's residence for a period of time. Sitaram by then was in Bangalore. Uma just returned or returned sometime thereafter from US. That's about it. Coming to the event, perhaps the idea behind memorial lectures, any memorial, is be it Alladi memorial lecture or any other memorial lecture, is that those who organize these meetings, I'm not talking about Uma, I'm talking about Justice Kuppuswamy, or people like him, perhaps they believed that humanity would benefit from the experience of the previous generations and their knowledge. I'm a little cynical in my nature. I'm reminded of Einstein. He famously said, there are two things infinite in the universe. One is the universe, and second is the stupidity of humanity. I'm sure of the second one, I'm not very sure of the first one, he said. So how many people benefit from, I'm not saying either casually or flippantly. I'll tell you the reason why I'm saying this in the context of. If somehow, I don't know how many of you have read Justice Hidayatullah's first lecture. Brother, did you read it? Hidayatullah, okay. Please read it. Hidayatullah's first lecture, it was published as the first item in compilation. He made very caustic comments about the Supreme Court in that lecture, in a very constructive way. It is not anything. There are two things he said distinctly. He said, when I was there, those days in the Supreme Court, division benches, judges sitting in 2 and 3 benches was not known. The Supreme Court mostly sat in constitutional benches. To start with, the strength of the Supreme Court itself was 7 when the court was constituted. Time to time, the numbers increased. But those days, the Supreme Court always sat in constitutional benches and decided profound questions of law. Rightly or wrongly is a different thing. I know what my brother is going to talk about today, starting with A.K. Gopalan's case. No, but rightly or wrongly is decided sitting in a constitutional bench. There is some modicum of stability in law when the court sits en banc. Then over a period of time, for whatever reasons, it requires a great deal of analysis. A lot of it is done already anyway. This practice of the Supreme Court sitting in division benches commenced. Now in substance, in effect today, I believe there are 17 Supreme Courts in this country with 34 judges, at least 16. First court sits at least 3. There are 16, 17 Supreme Court judges, Supreme Courts in this country. I'll tell you a hilarious anecdote. 1983, late Mr. N.T. Rama Rao became the Chief Minister. There was an election petition challenging his election in 1983. For various reasons, the matter went on, events moved very fast in 93, 83, 84. The government was pulled down and again came back and so many things. The election petition could not proceed. Then a second assembly election took place in 85. After the second election, the matter was finally listed before Justice Raghuveer. One day when the matter was called, I was representing as a junior counsel late Mr. N.T. Rama Rao. So I went to the court and Justice Raghuveer asked me, Chelameswar, why should I hear this matter? That assembly is dissolved already. The assembly, which was the subject matter of the election petition, dissolved. Should I really hear the matter? I told the court, my lord, I think it will have to be heard because there is an allegation of corrupt practice in that. If proved, the man is liable for disqualification for some time. Therefore, it will have to be heard. Then Justice Raghuveer said, I have my own doubts. This disqualification was automatic prior to Mrs. Gandhi's election case. But afterwards, the law was amended. Now it became a discretion in the hands of whatever is meant by that discretion in the hands of the Election Commission. So I would like to hear the Attorney General. I said, please go ahead. What is my problem? My client is sitting in the office as Chief Minister. If you want to hear the Attorney General, please do it. Notice was ordered. Mr. Parasharan, the Attorney General at that point of time, came sometime later. Obviously, Attorney General is a busy man. He took 1 or 2 adjournments. He came. I don't cut short the long story. At the end of it, after Mr. Parasharan completed his submission, Justice Raghuveer asked him, Mr. Parasharan, I have one more question, he said. And any lawyer, Attorney General, yes, my lord, I am ready at the service of the court. He said, Mr. Parasharan, last year, that was 1983, there were 2 judgments of the Supreme Court. One is Karunanidhi versus Hande, came early 83. A little later, another judgment, Madan Mohan versus Election Commission. Madan Mohan was a former minister in old Andhra Pradesh, present Telangana, from Siddipet or someplace. And there was an election petition, and there are two judgments in the same year which are almost contradicting each other. What am I supposed to do here sitting in the High Court when there are two contradictory judgments in the same year of benches of same strength? What am I, a High Court judge, supposed to do? Mr. Parasaran gave a devastating reply. He said, your lordships are very lucky. There are two judgments before your lordships to choose. But more often the Supreme Court nowadays, I am confronted with a situation where I rely on the first part of a judgment and my opponent relies on the later part of the same judgment, he said. And I'm not joking, my dear friend, I swear on everything I hold sacred, this is what exactly he said in 1983. Now, this is the problem of, that's why I said there are 16 Supreme Courts. Why it happened is there all matters. Now, the relevance in the context is when I started with Justice Hidayatullah's lecture, when he made this comment, he said the Supreme Court has become a two-judge court nowadays. He said it in 1983, 83 or 84, first lecture. Two-judge court. He said many other things. Please read that article. Now, why we don't become wise is, and I also add this. After I reached the Supreme Court, first 12 or 13 months, I sat with the J1, the then J1 of this country, Justice Altamas Kabir. Where I was sitting with him, he became the Chief Justice. A week before the date of his swearing in as the Chief Justice, Justice Kabir asked me, brother, next week I'm going to take over. You have any suggestions, kindly tell me whether we can improve the system. I mentioned about this lecture, Justice Hidayatullah's lecture. And brother, please do something about it. Make sure at least there's not possible that all the judges sit together in the Supreme Court India in the present condition. But at least make sure one or two permanent constitution benches are there. I passed on the lecture copy. I got it from the library, passed. Next morning, Kabir came and told me, brother, I've gone through it, but I don't think it's a practicable thing. So therefore, what is the purpose we are saying? That doesn't mean that we should not do it. The question is, the purpose seems to be this. To what extent, as I mentioned, Einstein's this thing, the human stupidity is infinite. Therefore, things go on. I just take one more minute. The topic chosen by, I don't want to say anything about Brother Murli, enough is said about him. Chosen is the what-if moments of the Indian Supreme Court and Constitution. I'm only reminded of one more anecdote. Brother, these are all imaginations and things. Well, we can't change history. Events can't be changed. We can't put the clock back. There was a famous case in the American jurisprudence called Brown versus Board of Education. For non-lawyers, for the information of non-lawyers, I may mention, for a long time, United States, till 1950s, maintained separate schools for blacks, separate beaches, separate restaurants, everything separate. The legality of which was challenged more than once before the Supreme Court on the ground that such a system violated the 14th Amendment of the American Constitution. To start with, the Supreme Court upheld the classification on whatever grounds. In substance, they said so long as the same table, same bench, same textbook is prescribed, doesn't matter whether the black children are asked to sit in a separate school. That's the logic adopted by the Supreme Court, which was changed in Brown versus Board of Education 1952 or 53. There is an anecdote associated with it, the what-if moments. Just before the hearing of that case commenced, one of the then American Supreme Court judges, if I remember right, it's Fred Vinson, died just before the commencement of the hearing. One of the law clerks of Justice Frankfurter, who was a member of the court on that day, informed Frankfurter about the death of the other judge. Frankfurter is generally known to have had a very caustic tongue, and he's supposed to have remarked, "This is the first ever confirmation I received that a God exists," he said. So it's one of those what if moments. Now, brother, it's for you to know, elaborate on what if.
You agreed to chair this session. I consider it an honor and privilege to be asked to deliver this year's Alladi Memorial Lecture. I am doubly honored that Justice J.Chelameswar, former judge of the Supreme Court of India, is chairing the event. Along with many a law student and legal scholar in this country, I have been in awe and admiration of the learning and erudition of Sir Alladi Krishnaswamy, who I learnt after reading his biography by his son Justice Alladi Kuppaswamy, did not quite fancy the suffix Iyer to his name. Having been brought up in a Pudur Dravida family of very modest means, and one that had a strong tradition of valuing scholarship, Sir Alladi rose to commanding heights in the legal profession through hard work and industry, often at the cost of his already frail health. On top of the stupendous feat of an unbroken 14-year stint as Advocate General of Madras, came the stellar contribution as a key member of the drafting committee of the Constitutional Assembly. Here, Sir Alladi was in the company of stalwarts: Baba Sahib Ambedkar, Dr. K.M. Munshi, Syed Muhammad Sadullah, Gopalaswamy Iyengar, Madhav Rao, and T.T. Krishnamachari. His contributions as a member of the Subcommittee on Fundamental Rights have been widely acknowledged and referred to in many a judgment of the Supreme Court of India. The country would be ever grateful to him for his role in shaping the Constitution of India, which continues as a guiding light of social, legal, and political life in our country, and which still holds out the promise and hope to the millions here struggling for justice. The choice of the theme for today's lecture is owed to the completion of 75 years of both the Constitution of India as well as the Supreme Court, giving an opportunity to review the institutions working over the years from a critical perspective. It has had its ups and downs and continues to, reminding everyone that it is not supreme because it is infallible, but that it is considered infallible only because it is supreme. This is a modification of the famous quote of Justice Robert Jackson: "We are not final because we are infallible, but we are infallible only because we are final." I have just one small addition to make to what Justice J.Chelameswar said about Chief Justice Fred Vinson. As it happened, they began hearing the Brown versus Board of Education case sometime in the term of October 1952. 9th December 1952, they concluded the hearings. And as it's wont in the Supreme Court of the United States, whereas Justice J.Chelameswar said they sit en banc, they had their conference. As it turned out, 3 of the judges from the South, Justice Hugo Black, but despite being from the South, he was very clear that segregation should go. But Justice Stanley Reed, Justice Fred Vinson, Chief Justice Fred Vinson himself, and Justice Tom, I forget the surname, from Texas, they had a huge problem in holding segregation to be unconstitutional. Justice William Douglas was very clear segregation had to go. And Justice Frankfurter was somewhere in the middle. He would like to be seen as a jurist. So the segregation was happening right there in the schools of Washington, D.C. So Justice Frankfurter said, okay, we can probably desegregate in D.C., but going all across the country in every state, it will be a huge problem. Now, Justice Frankfurter did not know what to do. So in that conference, and this is all written, if legal scholars want to know where I'm getting all this is from an excellent book by the Harvard professor Noah Feldman. The book is called Scorpions. The scorpions referred to in that book, and Justice J.Chelameswar will immediately agree, refers to 4 judges, very powerful gentlemen. Justice Frankfurter himself, Justice Hugo Black, another very strong personality, Justice William Douglas, and Justice Robert Jackson. Robert Jackson is whom we are quoting when we say we are not final because we are infallible. The same Robert Jackson had an interruption in his judgeship as Supreme Court of the United States when he went as prosecutor to the Nuremberg trial, completed that prosecution and came back. These 4 judges were so strong that they would see how to outwit each other. That's why the title of that book was called Scorpions. So coming back, Justice Frankfurter was in 2 minds. He said, best thing to do is what? Postpone. So he actively worked at deferring the hearings. So he suggested to all the brother judges, we have to hear all the southern states. We can't suddenly bring in this change. Maybe they have things to say. Maybe they'll tell us what difficulties there are. So he was already working at deferring the hearings and issuing a fresh rehearing notice when what Justice J.Chelameswar had happened. It was so fortuitous that Chief Justice Fred Vinson died. Eisenhower had taken over as president. So that was one more thing for Frankfurter to tell his judges, new government, new president, maybe he'll have something new to say. Fortunately for all of them, the person replacing Fred Vinson was none other than the great Earl Warren. And Warren had no difficulty at all. He was very clear in his mind. In fact, the beauty about Warren, like they say about John Marshall, is his ability to carry the court. So after Warren came, they had a unanimous verdict in Brown versus Board of Education. One of those rare occasions when the Supreme Court gives a unanimous verdict. The credit for which should definitely go to Frankfurter for deferring the hearings, and definitely the credit to Eisenhower. Earl Warren was the governor of California, a thoroughbred politician. He was to run on a ticket for president. But in the primaries, they chose Eisenhower. Greatness of Eisenhower, he knew whom to pick for Chief Justiceship. And that was a glorious period of the US Supreme Court. But one phrase used in that, I don't know why Justice J.Chelameswar has made me digress, after which I'll come back to the main topic. One phrase that they used in the Brown versus Board of Education was all deliberate speed. They said these changes should be made with all deliberate speed. In fact, there is now a book by that name, again legal scholars should note, it's by Professor Ogletree. The title of the book is All Deliberate Speed. Tells you how it took 2 decades and maybe 3 for actual desegregation to happen. At one point in time, many southern states said we'll close our public schools. It reminds me of what is happening today when you have Dalit cooks cook meals in the noon meal scheme. While I speak to you, there are many districts in southern Tamil Nadu where parents will not send their children to the government schools if there's a Dalit cook preparing the noon meals. This is the sad pass at which we are today in 2025. But everything has a resonance, across the pond, as they say, or across the waters. And what American constitutional history tells us has some resonance even in India, and we can relate to many of those elements here. So thank you, Justice J.Chelameswar, for bringing in Brown versus Board of Education. One usually associates the Supreme Court of a country with 2 characteristics: certainty and finality. However, in its actual working, there have been occasions when both these have come under challenge. The binding nature of the judgments of the Supreme Court of India on all other courts and authorities in the country is given formal recognition in Article 141 of the Constitution. This is in continuation of the common law tradition of stare decisis, which acknowledges the precedential value of rulings of the constitutional courts, the high courts and the Supreme Court, for later cases dealing with similar issues. First thing the judge will ask you, is there a judgment in your favor? Has this been said earlier? So this is a common law tradition of stare decisis, which you may not find in civil law jurisdictions. Within these institutions, there is an accepted practice of decisions of larger benches binding the smaller ones. For the non-lawyers in this audience, I hope there are not many. If there's a single judge, he is bound by a division bench of 2. The division bench of 2 is bound by a full bench of 3. But a single judge cannot differ from a coordinate judge, that is another single judge. If he says, no, I don't agree with this other single judge, he only has to refer it to a bench of 2. Of course, there have been numerous instances of indiscipline in the Indian judiciary. One classic example of indiscipline is you show a bench of 3 judges of the Supreme Court, another judgment of 3 judges of the Supreme Court. The first thing these judges ask, how to distinguish this. They don't want to say, okay, we disagree with this judgment, it has to go to a larger bench of 5. They'll say, no, we'll somehow distinguish it. So what has happened because of this indiscipline is, like Justice Parasran said, or Justice J.Chelameswar said, lawyers practicing in other courts are faced with 2 judgments of same strength, saying diametrically opposite things, and they're confused which one to follow. However, there is also the accepted practice of a bench doubting the correctness of the earlier decision of a bench of coordinate strength, leading to the question of the correctness of the earlier decision being referred to a larger bench. So we have the phenomenon of larger benches overruling the decision of previous smaller benches, sometimes after they've held the field for 2 or 3 decades. And here we differ from the US Supreme Court. In the US Supreme Court, a bench of 9 judges can overrule a bench of 9 judges. Whereas in our country, it's only a bench of larger strength that can overrule a bench of smaller strength. That this has happened with fair regularity through the Supreme Court's 75-year history is not by itself unusual if one views the workings of other counterparts of the institution in democracies around the world. That is in the very nature of judicial function, where the court is responding to the changing societal values and ways of thinking. After all, the court is the final interpreter of the Constitution, which by itself has been viewed as a living organism that has to evolve to suit the history and genius of the nation. To recall one of the many aphorisms of Oliver Wendell Holmes, Justice Oliver Wendell Holmes, the law is forever adopting new principles from life at one end and sloughing off the old ones at the other. But then we also have a different kind of a problem when mistakes, and sometimes serious ones, can take place in the same case. One example is the Antule case in 1987, where by a 5:2 majority, the court reversed the course deploying Article 142 and recalled its earlier orders ordering an expedited trial of the corruption cases against the former Chief Minister of Maharashtra, Abdul Rahman Antule, by a special judge of the Bombay High Court. Basically, they said this is going to take a long time. Let's bypass the special court in the district judge level. We'll take the trial to the High Court itself. Let a single judge of the High Court conduct the trial. This was challenged, saying this is an extraordinary procedure. Also that you never heard me when you said this. Thirdly, that what about my appeal? If a special court in the district judge level had conducted my trial, I would get an appeal to the High Court. Now my only chance is in specially petition to the Supreme Court. And they accepted these pleas. They accepted this plea by a 5:2 majority. Of course, it was a stellar, and I would really consider it a stellar dissent by Justice Venkatacharya, which is worth reading for all the legal scholars present in this room. It did it again as a half measure and again unsatisfactorily in the Bhopal case. So I'm talking of in the same case making mistakes and how do you correct them. In the Bhopal case, where it revived the criminal cases while declining to reopen the civil claims. More recently, and this is really something that we should be worried about, in Ankush Maruti Shinde, the Supreme Court reversed the convictions and sentences, and 3 of them were death sentences, of 6 persons wrongly convicted of the grave offenses of rape and murder, 16 years after they were arrested and remained in judicial custody throughout. In 3 of their cases, they enhanced the life sentence to death without hearing them. It required a review petition to correct all these mistakes. And 16 years had passed by in the meanwhile. However, even this review exercise has been admitted by the court itself to be both inadequate and incomplete as a remedy. So in the 52nd year of its working in 2002, the Supreme Court came up with another innovation, the curative petition. It now formally acknowledged in Rupa Hurra versus Ashok Hurra that there could be occasions of miscarriage of justice even after the remedy of a review petition had been exhausted. This, according to the court, became necessary because, and I'm quoting the Supreme Court here, we are persuaded to hold that the duty to do justice in these rarest of rare cases shall have to prevail over the policy of certainty of judgment, as though it is essentially in the public interest that the final judgment of the final court in the country should not be open to challenge, yet there may be circumstances where declining to reconsider the judgment would be oppressive to the judicial conscience and would cause perpetuation of irremediable injustice. It circumscribes this remedy by hoping that it would be resorted to in the rarest of cases, by showing two things: either that the party affected was not heard, or that the judge failed to disclose a conflict of interest, leading to the decision being vitiated by bias. Also, the existence of one of these grounds had to be certified by a senior advocate. In practice, of course, even after the dismissal of a curative petition, there have been instances where the court's doors have been knocked. For instance, where the juvenility of an accused at the time of commission of the crime was overlooked. In such cases, the court has entertained a petition under Article 32 in order to revisit the correctness of the conviction or sentence handed down in the case. What the court is formally acknowledging in the above instances is that it is, of course, fallible, that its choices of decision in a given case may not have been correct. On the positive side, this means that those who have lost their cases up to the final court do not have to lose hope entirely. The flip side, of course, is that those who have succeeded cannot also rest assured that the final word has been said in the litigation. Not indeed a happy state of affairs, considering that several years pass before the litigation arrives at the terminus of the Supreme Court. All this makes one wonder, does the Supreme Court get it right most of the times? In a scenario where every court at all levels in the Indian judiciary is overburdened, far beyond the judge's carrying capacity, and the work of a judge, unlike manufacturing cars in an assembly line, is both cerebral as well as emotional, mistakes are asking to be made. A deserving case could get thrown out at the threshold, and a relatively less deserving one could take up a lot of the judicial time. This is even starker at the level of the Supreme Court, where barely 1 in 10 cases makes it past the first post. For anyone watching the live streaming of some of the proceedings in the Supreme Court, you'll understand what I'm saying. Even before the counsel can open his submissions, the judge is already saying there is nothing in your case. So sometimes as lawyers, we would earnestly hope that the client is not sitting in the room. And now you can't hope for that because it's all there on public display. But this part of the Supreme Court's functioning, I would say, has not changed one bit in the last 20 years. There's a real pressure of work on every judge of the Supreme Court in India. I don't think any other top court in any part of the world, judges are required to read 60 to 65 paper books in one day. And it's really a huge load on the judges of the Supreme Court. They set down less than 40 to 45 cases for oral hearing. They entertain just about 180 to 200 petitions at all, if they do. So the workload is not comparable at all. Agreed that this is not a new phenomenon as far as the Indian judiciary is concerned. The problem of too many cases, too few judges, mounting arrears, poor infrastructure are all problems inherited from the colonial times. As part of my research for the PhD that Professor Uma was talking about, I came across Lord Cornwallis's document, where he talks of the Supreme Court of the Calcutta, late 18th century, and he says this very same things: too many cases, too few judges, too much delay in courts, costs of litigation, uncertainties, all of this. Yet, with some of the momentous occasions when those decisions of the courts have altered in a palpable way the course of the country's political and legal history, one cannot help wondering, what if the court had in that particular case decided it differently? Would that have changed what happened thereafter? Many would say that this is a no-brainer. Of course, the ensuing developments would have been different, and anyway, this is just not some idle speculation serving no practical purpose, since it is always easy in hindsight to say, oh, should not the court have decided this case the other way? Are we going to be able to change the way the court functioned then? Or even more pertinently, will it function differently hereafter? Something that I think I heard Justice J.Chelameswar say in his opening remarks. Well, at this stage, all I can say is that as this lecture progresses, some of you may find answers to these questions, while some may not. The purpose of this exercise is not to indulge in cerebral puzzle solving or judicial crystal ball gazing, but use this as an introspective and reflective tool to understand the nature of the judicial process, its limitations, and perhaps explore in a responsible way the possibility of minimizing the uncertainties and fallibilities of our courts. I must straightaway enter a caveat. No system, much less the legal and judicial system, can be said to be ideal. Let us now get down to the central part of the lecture, a sampling of the what-if moments in Indian constitutional history. And within that larger set, when I speak of the Indian judicial history, which is an inextricable part of it, I will try and advert to the what-if moments on the judicial administration side. And with Justice Chelameswar here, that will be of extra interest to all of us, in the context of choice of judges. Again, I wish to emphasize that this is but a small representation of a much larger cohort of instances over the past 75 years. It is entirely possible that to another person, a different set of instances may illustrate the point I'm making better. Now for the what-if cases. So it is 15th August 1947 midnight, intervening 1415. Pandit Nehru is giving the stirring twist of destiny speech. In one small central jail in one remote part of southern India in Kannur, there's one detaining in a solitary cell. He's able to hear voices of Jai Hind and all kind of, exclamations. He steps outside the cell and he's told Pandit Nehru's speech is being aired. So what he does is takes the flag, Indian flag. Some of them have it, some prisoners. And with a group of prisoners, he marches down that corridor. There is a central jail number 3 in the Kannur jail complex. They manage to get to the roof of that and hoist the Indian flag. For hoisting that Indian flag, this gentleman is taken before the Additional District Magistrate of Calicut, and they charge him with sedition under section 124A for acting against the interests of the British Crown. The person I'm talking about is A.K. Gopalan, the communist leader. I'm quoting his own words. I was taken to the Calicut ADM's court after August 15th on a charge that had stirred up the people against His Majesty the Emperor. This is happening after 15th August 1947. Independence was achieved on August 15th. I was arrested after that on a treason charge created by the British under a law popularly termed as Section 124A. The people were amazed. What sort of a government is this? And Gopalan makes the following statement in the court. Of course, now I don't think Gopalan will be allowed to even make this statement. I am proud that I am being tried for creating enmity against the legally constituted Emperor of British India. All freedom lovers in this country and the leaders of the freedom movement from its birth, like Nehru, Gandhi and such leaders, have tried to create enmity against the Emperor's government. Mahatma Gandhi has been proceeded against this under section 124A IPC for working towards the same end. As a result of all this, His Majesty's government and British India have ceased to exist today. Many of my colleagues who committed the same crime along with me have become ministers and governors. And this is the best part. He says, there is some incongruity in bringing me to trial at this time when on the face of it we have just achieved freedom. I'm sorry that things should have come to such a pass. So the poor gentleman is released on 12th of October 1947, but promptly reasserted under the detention law on 17th December 1947. His detention continues. This is remarkable. After India's independence, in 1950, a Preventive Detention Act of 1950 is enacted by the Parliament. Mr. Gopalan's detention is continued under the new law, at which point he files the writ petition. Mr. M.K. Nambiar, Mr. K.K. Venugopal's father, argues his case before the Supreme Court. The Supreme Court is not prepared to see the incongruity of all this. So as Justice Chelameswar was saying, those days, they tried to sit en banc. They were not bothered about the odd even numbers. So this was heard by a bench of 6 judges. Justice Mahajan dissents on a very small point, but says, no, the detention is all right. The only judge who's prepared to see the interconnectedness of Articles 21, 22, and Article 19(1)(d), which is freedom of movement, the only judge was Fazil Ali. So, which is why Fazil Ali's dissent is a celebrated dissent in A.K. Gopalan. And in the Justice Puttaswamy judgment, where Justice J.Chelameswar was on the bench, the three dissents that are referred to, one of them is this dissent of Justice Fazil Ali. And he's very clear. He says, however literally we may construe the words used in 19(1)(d), and however restricted may be the meaning we may attribute to those words, there can be no escape from the conclusion that preventive detention is a direct infringement of the right guaranteed under 19(1)(d). The learned judge, hailed as a great dissenter, was also clear that the word law in Article 21, for the non-lawyers, Article 21 says nobody can be deprived of life and liberty except according to procedure established by law. So what does that word law mean? The word law in Article 21 means valid law, and procedure means certain definite rules of proceeding and not something which is a mere pretense for procedure. Fazil Ali further pertinently observed, to my mind, and this is so important, the scheme of the chapter dealing with the fundamental rights does not contemplate what is attributed to it, namely, that each article is a code by itself and is independent of the others. So this he's speaking in 1950. In my opinion, it cannot be said that Articles 19, 20, 21, and 22 do not to some extent overlap each other. The case of a person who is convicted of an offense will come under Articles 20 and 21 and also under Article 22 so far as arrest and detention in custody before trial are concerned. Preventive detention, which is dealt with in Article 22, also amounts to deprivation of personal liberty, which is referred to in Article 21 and is violation of the right of freedom of movement dealt with in Article 19(1)(d). So the interconnection is made. Now looking back, we'll say, wasn't this so obvious? Why did it take 20 years for the Supreme Court to come to this point? So sorry.
Whether with your permission and with apology to the House, may I just add a very short anecdote which fell from late Justice Kuppuswamy. One of those evenings when I was with him, incidentally mentioned, Justice Kuppuswamy, as a young lawyer in 1950s, relatively young lawyer, was in the Supreme Court for some case. And some other case was being argued at that point of time in the Chief Justice Court, and Justice Kuppuswamy was waiting for his turn. And the advocate appearing in the other case, which was being argued, cited A.K. Gopalan's case in support of whatever submission he was made. Brother, I congratulate you that you culled out some law from what they have decided, A.K. Gopalan. And Justice Kuppuswamy told me, when the judgment was cited, one of the judges in the bench said, Mister, don't cite the judgment. We have not decided anything in that case except that Gopalan should remain in jail. Mind you, this is what exactly Justice Kuppuswamy told me. Sorry for the interruption.
Unsurprisingly, the decision in Gopalan was considered regressive. In his characteristic style, Mr. K.G. Kannabiran terms it as the first Indian-made foreign judgment. The same approach was to be found in other preventive detention cases like S. Krishnan versus State of Madras, where again by a 4:1 majority, the court permitted open-ended, indefinite preventive detention. Only Justice Vivian Bose protested, saying, and I'm quoting, Articles 21 and 22, and this is classic, this sentence is classic. Articles 21 and 22 confer a fundamental right and give a fundamental guarantee. It is therefore the duty of the court to see that the right is kept fundamental and that the fullest scope is given to the guarantee. It is our duty to ensure that the right and the guarantee are not rendered illusory and meaningless. Therefore, wherever there is scope for difference of opinion on a matter of interpretation in this behalf, the interpretation which favors the subject must always be used, because the right has been conferred on him and it is the right which has been made fundamental and not the fetters and limitations with which it may be circumscribed by legislative action. So the right is fundamental and the restriction cannot be made to override the right. So, what if the dissents of Fazal Ali in Gopalan and Vivian Bose in Krishnan had in fact been the majority opinion in each of those cases? For one, the country need not have waited for another 2 decades for these views to be accepted as the correct interpretation of Part 3 of the provisions of the Constitution. That happened only in 1970 in the bank nationalization case by a 10:1 majority, the only sole dissenter being Justice A.N. Ray, who later becomes CJI. The majority now held Part 3 of the Constitution weaves a pattern of guarantees on the texture of basic human rights. The guarantees delimit the protection of those rights in their allotted fields. They do not attempt to enunciate distinct rights. This was enunciated most forcefully in the much celebrated Maneka Gandhi case, another 8 years later, 1978. This is Krishnaiah's words: "No article in Part 3 is an island but part of a continent." By this time, preventive detention became what Professor Upendra Bakshi terms a habit of the state to govern by preventive detention and a judicial habit to say it is okay. The ruling establishment found it convenient to criminalize political dissent and lock away opponents, bypassing the judiciary and the CRPC. For again, non-lawyers, once you're held under the preventive detention law, you can actually bypass the CRPC. You don't have to produce the person before a court. He's only produced before an advisory board set up by the executive. And if that advisory board does not confirm the detention, of course, the person can be freed. That doesn't happen at all. In the 99% cases, they just mechanically affirm the detention. After which you have to go to the High Court or the Supreme Court under Article 32 to question the preventive detention. And usually it is for 1 year. By the time the Supreme Court or the High Court decides, at least 8 to 9 months have gone off. And this is the state of affairs here, even in 2025. We today have a plethora of nearly 20 plus detention laws in the country, not just by Parliament, but by the state legislatures as well. Article 22(4) of the Constitution, which authorizes this, stands at odds with the rest of Part 3. The exceptional has been routinized. It could have been insisted right at the launch of the Constitution, what Justice Vivian Bose and Justice Fazal Ali said. Such an approach would have put paid to the apprehensions expressed by many a member in the Constituent Assembly that such a draconian law that could help an executive put away inconvenient political dissenters should not be passed. As a result, a rights-respecting culture among law enforcers is yet to take root. The state persists with extraordinary laws like the Armed Forces Special Powers Act, the Unlawful Activities Prevention Act, the Maharashtra Control of Organized Crime Act, and similar laws where suffering incarceration without trial for years on end is no longer unusual. One such punitive detention law, it's no longer preventive detention, it's called punitive detention. One such punitive detention law was the MISA, Maintenance of Internal Security Act, used by Mrs. Indira Gandhi to detain virtually each of her political opponents during the dark period of Indian political history when it was under the internal emergency. That brings us to the second of the what-if cases. There is a trajectory now that requires to be traced, keeping in view what was happening on the political front. By 1967, the Congress was electorally performing badly. The Supreme Court, having held in both Shankari Prasad in 1951 and Sajjan Singh in 1965 that the Parliament's power to amend the Constitution was absolute and that it included the power to exclude fundamental rights altogether, now held the opposite in Golaknath in 1967 by a narrow 6-5 majority. Justice Mudolkar, in his concurring opinion in Sajjan Singh, which was in 1965, had suggested that Parliament could not amend away the basic structure of the Constitution. That was the first time in Mudolkar's opinion the phrase emerges. This was built upon by M.K. Nambiar, arguing for the petitioners in Golaknath, relying on the seminal work of German professor Dieter Conrad. Conrad, in fact, gave a series of lectures in the Banaras Hindu University in 1965. And that's what got many of the legal scholars thinking. However, in Golaknath itself, Justice Subbarao did not pick up this argument, since the majority found other reasons to rule on the validity of the 17th Amendment to the Constitution, which was challenged in that case. Basically, it included the Punjab Land Reforms Law into the 9th Schedule. For the first time, the court invoked the doctrine of prospective overruling and saved all amendments made thus far, including the 17th Constitutional Amendment. Meanwhile, on the political front in 1969, the Congress split into the Indian National Congress Requisitionists, INCR, and the Indian National Congress Organizational, INCO. INCR, which was headed by Mrs. Gandhi, continued in power, propped up by a coalition. In 1970, the government suffered two major reverses in the Supreme Court. The attempt at bank nationalization failed, as did the abolition of privy purposes by an executive fiat after having failed to pass the measure through Parliament. By this time, Justice Subbarao had resigned. If you remember, he resigned as Chief Justice to contest the presidential elections. Justice K.N. Vanchu's term as CJ had ended, as had Justice Hidayatullah's. Around this time started the first moves by the executive to appoint committed judges to the Supreme Court. The strong rumor, and whenever this gets printed, we'll have the footnotes for this. The strong rumor was that the government of the day wanted to appoint the erstwhile card-carrying communist Mohan Kumaramangalam, who had joined the Congress in 1967 and stayed with the INCR post the split as Chief Justice of India. Kumaramangalam was just 54 years then, so he would have continued as Chief Justice for 11 more years as Chief Justice of India. But the Supreme Court bar protested through a resolution dated 27 November 1970. So we are on strong footing here that this is all part of the political history now in the country. The attempts, they didn't stop there. They tried attempting to get J.C. Shah, the next in line after Hidayatullah, as Chief Justice of India, superseded, saying, oh, no, he has only 1 month. And after him, Justice Sikri, S.M. Sikri, who was a direct appointee. One of the first direct appointees to the Supreme Court from the bar was Justice S.M. Sikri. He was then the Advocate General of Punjab. They tried to bypass both these names and failed. Again, the bar protested very strongly. The government was still a coalition government, so they were not so bold to go ahead with their plans. But everything changed in the general elections of 1971. Mrs. Gandhi's INCR won a thumping majority with 352 seats. So then it was 350 par. Soon after came the liberation war of Bangladesh, which boosted her image politically. I'm only talking of Mrs. Gandhi. People should not get ideas about, what is happening more recently. The PM's, buoyed by these successes, she again trained her eyes on the judiciary, determined to ensure the reversal of Golaknath. It was a thorn in their side. They said, what is this? Parliament's power is being taken away. How can some wise men sitting in Tilak Marg decide what the Parliament can and cannot do? The Prime Minister's inner coterie included Kumaramangalam, Siddharth Shankar Ray, both who were ministers in the Union Cabinet at that time. The efforts at packing the judiciary resumed right earnest. By the time the hearing of the Keshavananda Bharati case, and I'm going to call it as the fundamental rights case hereafter, by a 13-judge bench to consider the correctness of Golaknath, that was 11-judge, by the time the hearing commenced in November 1972, 8 judges have been appointed to the Supreme Court by that government. From a variety of sources, now we have authoritative sources, including Justice Jagan Mohan Reddy's autobiography, The Judiciary Has Served. It is now clear that of the 8 judges, 2 were nominees of the Law Minister, Mr. Gokhale. Those 2 were the senior, Yashwant Vishnu Chandrachud, Y.V. Chandrachud, and Justice Palekar, D.G. Palekar, both from the Bombay High Court. One was of Mohan Kumaramangalam. This was Justice K.K. Mathew. In fact, Mohan Kumaramangalam wanted to bring in Krishna Iyer even at that time, but faced huge resistance from within the Supreme Court. 2 were nominees of Siddharth Shankar Ray, Justice Mukherjee and Justice S.C. Roy. Unfortunately, Justice S.C. Roy did not survive. He died soon after. And 2 from Allahabad High Court who claimed very proudly that they were the nominees of the Prime Minister herself. One was Mirza Hamidullah Beg, the other was Justice Dwivedi. Justice Khanna, H.R. Khanna alone, who was appointed during this time, he alone was Justice Sikri's, Chief Justice Sikri's choice. Of these 8, 5 constituted the dissent in the fundamental rights case. So this was clearly the first successful packing of the judiciary. What happened in the fundamental rights case that was argued over 68 days is now well known. While by a 7:6 majority, 11 separate opinions running to 703 pages, the court on 24th April 1973, 2 days prior to Justice Sikri's retirement, held that Parliament did have unlimited power to amend the Constitution, including abridging, this word abridging is very important, including abridging the fundamental rights, and therefore it overruled Golaknath. It could not in that process emasculate or abrogate or destroy. So you can abridge, but you cannot abrogate the fundamental rights or destroy the basic structure of the Constitution. The majority, with Justice H.R. Khanna being the swing vote, accepted the theory of implied limitations in the amending part of the Parliament. Not all the judges in the majority were ad idem as to what constituted the basic structure. Many said that the preamble reflected the basic features. It was all or some of these, that is the supremacy of the Constitution, separation of powers, secularism, democratic and republican form of government, federalism, the freedoms in Article 19, sovereignty, integrity, egalitarian society. Although Justice Khanna said that these did not include the fundamental rights, in a subsequent judgment in Indira Nehru Gandhi versus Raj Narayan, which I'll hereafter refer to as the election case, he explained that he only said that it was not part of the basic structure in relation to right to property. In the same case, Justice K.K. Matthews said, and I quote, "The concept of basic structure as a brooding omnipresence in the sky, apart from specific provisions of the Constitution, is too vague and indefinite to provide a yardstick for the validity of an ordinary law." So even very recently, the Supreme Court has reiterated this, that you can test a constitutional amendment's validity with reference to the basic structure, but you cannot test the validity of a statutory law with reference to the basic structure. In a strange, so what Justice Sikri, Chief Justice Sikri did, when he found that there were 11 opinions, it's very hard to distill a ratio, he said, let me draft what I think is the majority view. So in a separate sheet of paper, he drafts what he thinks is the majority view. Unfortunately, that sheet of paper is signed by only 9 of the 13 judges. 4 of them refused to sign that so-called summary or ratio of the judgment of the majority in Keshavananda Bharati. And the 4 judges who refused to sign are Justice A.N. Ray, Justice K.K. Matthew, Justice M.H. Baig, and Justice Dwivedi. Thus, in a strange anticlimax, although Golaknath is overruled, the fundamental rights case perhaps went even further in curtailing the amending power of the Parliament. Many years later, in fact, there are scholarly works now saying that the Keshavananda Bharati case actually did not overrule Golaknath. Because now what they've done in 2007 in the Coelho case is to say you may put it in the 9th schedule, but we're still going to test it against fundamental rights. In a sense, they've actually said in the Coelho case, we cannot think of a basic structure de-horse part 3. So they've actually said fundamental rights does constitute part of the basic structure of the Constitution. Also, we now have an expanding, what I would say, scenario as far as basic structure is concerned, because judicial review is now part of the basic structure of the Constitution. So they've reiterated that in the Quixote Holawan case, the Chandrakumar case, and so on and so forth. And then, of course, in Minerva Mills. Now, there's a funny aside, and we should have some lighter moments in this lecture. So, 13 judges are hearing the Keshavananda Bharati case. Mr. Palkiwala gets up. They're firing questions at him. Firing questions about Golaknath, Sajjan Singh, Shankari Prasad. Because he starts reading Golaknath, saying this is what is required to be overruled. So I have to defend it. And they're not allowing him to make progress. Mr. C.K. Daftri is known for his sense of humor. He's the appearing for the central government. He meets Chief Justice Sikri at a social gathering. And meanwhile, Mr. Daftri has had a conversation with Mr. Palkiwala. So he says, Nani, how is the case going? So he says, Chandubai, they're not even letting me proceed. Not even few pages of Golaknath I have crossed. So Sikri, Chief Justice Sikri at the social gathering asks Mr. Daftri, how come you're not seen in the court? He says, no, I'm getting reports. I have a friend's niece, a young girl who's sitting and watching the proceedings. And she's giving me full reports. She's very impressed. And this is the words he uses. According to her, the case was going on very well, and she was pleased with the gravity, wisdom, intelligent remarks of the judges from time to time. But she said there was one discordant note. While these 13 wise and dignified judges were contributing so much to the case, from time to time, standing opposite them was a young person in black coat and robes trying to interrupt them. She felt that he should be removed. So Sikri then smiled and he told Daftari, I've got the message. And from the next day, Palkewala could actually make progress in the case. Now for the what ifs. If Golaknath had not happened, committed judiciary would not have happened. The consequential 24th, 25th, and 29th constitutional amendments that were challenged, because each of these amendments, and you know this is a legislative device. As a parliament, if you are frontally challenged by the judiciary and they say the law made by you is bad, the parliament can actually bring out an amendment. We call it the mischief rule. The court points out what is wrong with the law. The parliament sets it right and passes the law. And sometimes gives it retrospective effect. This is a known device, nothing unusual. But it's a lot of pain. So if Golaknath had not happened, the 24th, 25th, 29th amendments would not have happened. They would not have been challenged before a larger bench in the fundamental rights case. The fundamental rights judgment may not have been delivered, but most importantly, the famous supersession of 3 judges in line for Chief Justiceship, Justice Shelath, Justice Hegde, and Justice Grover, who were part of the majority of the fundamental rights case and who were bypassed for appointing Justice A. N. Ray, their junior, as Chief Justice of India, that supersession would not have happened. Incidentally, Justice Ray, I think I've already mentioned, was a dissenter in the bank nationalization case. In Parliament, so the Keshavananda Bharati judgment is 24th April. 26th April, they were appointed Justice A. N. Ray on the retirement of Justice Sikri as Chief Justice of India. The bar protested, all that is part of history. In Parliament, and this is in the 1st or 2nd of May, 1973, Mohan Kumarangalam stoutly defended the move, and he says quite brazenly, and I'm quoting, the social philosophy of the superseded judges did not coincide with the thinking of the government, which had won a massive mandate from the people. We did not want to appoint even Sikri, but at the time our plate was too full because of the dispute over the crisis within the Congress party. Referring to the reverses suffered by the previous government in the Supreme Court, he went on to ask, was it not right for us to think in terms of a more stable relationship between the court and ourselves? Is it not good that we should have, as a Chief Justice of India, a man who will be able to help to put an end to this period of confrontation? You can recall some meetings that recently took place when people started talking of Lakshman Rekha. A person who will be able to give a certain continuity, a certain permanence to the approach made by the court to the important problems that come before it. Doesn't stop here. Kumaramangalam unfortunately died in a plane crash on 31st May 1973. By this time, he had succeeded in bringing Justice V.R. Krishna Iyer from the Kerala High Court only after 3 years of his judgeship to the Law Commission of India as Gajendra Gadkar's deputy. Gajendra Gadkar, the former Chief Justice of India, was chairing the Law Commission. However, while he could get K.K. Matthew to the Supreme Court, his attempts at getting Krishna Iyer failed, mainly because of the stout opposition of Justice K.S. Hegde, who prevailed upon Chief Justice Sikri not to bring Krishna Iyer to the Supreme Court. On his part, Justice Shelath, who was also from Gujarat, had ensured that Justice Bhagwati's elevation to the Supreme Court is delayed. They brought Justice Y.V. Chandrachud first. With Gokhale and Gajendra Gadkar battling for Y.V. Chandrachud, he came earlier than Justice Bhagwati, and this was a grudge that Justice P.N. Bhagwati bore against Senior Chandrachud all his life. There was a dramatic change with the judgment of the fundamental rights case. By end of May 1973, Sikri had retired. The 3 next senior most, Shelath, Hegde, and Grover, were gone. Thus, the roadblocks for the elevation of both Bhagwati and Krishna Iyer disappeared. Both were sworn in on 1st July 1973. But for this change, Krishna Iyer may not have made it to the Supreme Court at all. There was no one left there batting for him. Although I believe Mr. Siddharth Shankar Ray claims credit for saying, despite Mohan Kumaramangalam dying, I somehow batted and made sure that Justice Krishna Iyer comes to the Supreme Court. Right. And Justice Bhagwati, P.N. Bhagwati may have come, if at all, much, much later. Because Justice Shelath would have been even for that brief while as Chief Justice of India. In the absence of these 2 stalwarts, and we are talking of 2 stalwarts being Justice Krishna Iyer and Justice Bhagwati, the legal aid movement and the launch of the PIL may not have taken place at all. So just think of the dramatic differences that could have happened. Now I come to the election case and the habeas corpus case. The country witnessed the most dramatic moment in its 28-year history when on 12th June 1975, Justice Jagan Mohan Lal Sinha of the Allahabad High Court set aside the election of the sitting Prime Minister of the country, Mrs. Indira Gandhi, to the Lok Sabha from the Rai Bareli constituency in the 1971 general elections. As noted earlier, that election saw the INC-R win with a huge majority of 352 seats. The High Court agreed with the contention of her challenger, Rajnaran, that she had exceeded the maximum spending limit, had misused government machinery in the campaign, had indulged in corrupt practice with her private secretary, Yashpal Kapoor, who was, as a public servant, campaigning for her, even while his resignation had not been accepted, and after she herself had held out to be a candidate. The provision of the Representatives People Act said, you are a candidate from the date you hold out to be a candidate. Justice Sinha suspended the judgment for a period of 20 days to enable Mrs. Gandhi to appeal. The appeal filed by Mrs. Gandhi in the Supreme Court was argued before the vacation bench presided over by Justice Krishna Iyer. Mr. Nali Palkhiwala, eminent senior counsel, appeared for Mrs. Gandhi, argued for a complete stay of the judgment. Mr. Shanti Bhushan, who appeared for Rajnaran, opposed the prayer. Arguments were heard on 23rd June 1975. The dates are very important. A 23-page order was pronounced on the next day by Justice Krishna Iyer, that is 24 June 1975, granting a conditional stay. Mrs. Gandhi could continue as Prime Minister, but would not be able to vote in Parliament. This conditional stay was to continue till the appeal itself was finally heard. He set down a date for appeal, 11th August 1975. Within 24 hours, the famous proclamation of emergency happened. People are still in doubts whether it ever went before the cabinet. It reached Rashtrapati Bhavan at an odd hour and signed by President Fakhruddin Ali Ahmed in very odd circumstances. An announcement of this internal emergency was made on 6 a.m. on 26 June 1975 over the radio. This was on top of an external emergency that was already in force, having been announced after the 1971 war, the Bangladesh Liberation War. And for some reason, that emergency had not been formally revoked, despite the hostilities having ended. Under Article 359, the freedoms under Article 19 stood automatically suspended. The press was muzzled. The draconian MISA, enacted in 1971, was amended for greater severity and deployed indiscriminately and extensively against anyone and everyone perceived as capable of questioning the establishment. Several of the prominent leaders of the parties in opposition, including Shri Jayaprakash Narayan, Shri Morarji Desai, were placed under arrest. By separate presidential orders, the right to approach the High Court in Article 226 was suspended. In other words, the loss of liberty was unable to be questioned by individuals by knocking the doors of the constitutional courts. There was no legal redress for violation of the fundamental rights. Politically, there was a huge upheaval. This was perhaps the darkest phase in independent India's 25-year-old constitutional history. It was as if there was no rule of law, but only rule by law. On 10th August 1975, one day before the election appeal was to be heard, the Parliament, with most of the opposition MPs in jail, hurriedly passed the 39th Constitutional Amendment that inserted Article 329 capital A in the Constitution, whereby the elections to the offices of the President, the Vice President, the Prime Minister, and the Speaker of the Lok Sabha were insulated from judicial challenge. The case that was to be taken up on 11th August had necessarily to be postponed in view of this development and came to be heard on 24th August 1975. Apart from challenging the validity of that amendment, Rajnaran also questioned the amendments made to the Representatives of the People Act with retrospective effect, which undid 5 of the 7 grounds of corrupt practices, including the 2 on which election of Mrs. Gandhi had been invalidated, namely that she had spent more than the permissible limit for her election, had misused government machinery, and had a government servant campaign for her. The amendment actually said you become a candidate only when you actually file the nomination paper, which is accepted. They said a person resignation can be accepted with retrospective effect. They said if the government spends for your security, you may be a prime minister, if they spend for your security, it won't be counted as expenditure for the election. So every one of the grounds on which Rajnaran succeeded, by retrospective amendment to the Representatives People Act, they validated all of that. So he argued, listen, how can you retrospectively change all of this? If I knew that government machinery can be used and UP was under the opposition at that point in time, I would have had the government machinery also for my campaign. So what is surprising is, while the Supreme Court, and this included Justice Khanna, I think this is the point that we seem to miss in constitutional history, on 11th November 1975, a judgment was given, unanimous judgment by a 5-judge bench of the Supreme Court, where they struck down the 39 constitutional amendments saying judicial review is part of basic structure. So far, so good. But they completely approved this retrospective amendments to the Representative People Act. As a result, Mrs. Gandhi's election was validated. So the judgment of Justice Jagmohan Lal Sinha was actually reversed by the Supreme Court. In the midst of all this, Chief Justice Ray does something. On his own, he constitutes the 13th-judge bench. He says we need to review the fundamental rights case. They said Mr. Palkiwala's performance for the 2 days before that bench was so stellar that most of the judges, apart from, of course, Justice Ray himself, felt we shouldn't go this far. So Justice Krishnaiyer says that in his autobiography, that by the second day, the message went to Justice Ray that this is not on. So on the second day, on his own, Justice Ray says the bench is dissolved. So that attempt failed. No, Justice Matthew. Apparently, Krishna says Matthew went and told Ray this. So, this was the first 3 significant rulings during the dark period of the emergency. The second is the most celebrated, I shouldn't say celebrated, more notorious. ADM Jabalpur versus Shivkant Shukla. There, except with Justice Khanna dissenting, the 4, and that majority comprised Justice Bhagwati and Justice Chandrachud. They ruled that once there was a presidential order suspending the enforcement of fundamental rights to life and liberty guaranteed by 21, a person who is deprived of his liberty by detention order, even though if it was passed mala fide, could not approach the court for redress. Then there was a 3rd judgment. I'll just skip that because of lack of time. All this was pronounced to be a serious, a very grave mistake by the Supreme Court. Later, almost, 76 to 2017, more than 40 years later, nearly 40 years later, 41 years later, in the Justice K. Puttaswamy privacy judgment. And the junior Chandrachud, now this is Justice D.Y. Chandrachud, saying, and I'm quoting, when histories of nations are written, certain judgments should be confined to the archives as they should never have been written. The view taken by Justice Khanna must be accepted, and accepted in reverence for the strength of its thoughts and the courage of its convictions. Now the what ifs. What if Justice Jagmohan Lal Sinha had not set aside Mrs. Gandhi's election? Then the election case would have not been filed. 39th Amendment would not have happened. The retrospective Representation People Act amendments would not have happened. Krishnaiyer would not have passed a conditional stay order. That order was not an innocuous one. See what Justice Krishnaiyer says in that order. He says, after all, the High Court's finding, until upset still holds, however weak it may ultimately prove. He's already anticipating this judgment is very weak. The nature of the invalidatory grounds upheld by the High Court, I agree, does not involve the petitioner in any of the graver electoral vices set out in Section 123 of the Act. Maybe they're only venial deviations. This is Justice Krishnaiyer. But the law as it stands visits a returned candidate with the same consequences of invalidation. And then again, this is what he says. Draconian laws do not cease to be law in court, but must alert a wakeful and quick-acting legislature. Clear message to Parliament, listen guys, what are you doing? Wake up. Save your Prime Minister. Precisely that's what the Parliament did. They said, okay, retrospectively amend the Representative People Act. So this is not an innocuous judgment. Professor Bakshi feels that maybe an unconditional stay may not have precipitated the emergency and all the draconian measures that followed. On the other hand, it is possible that, considering the nature of the electoral vice, a brazen misuse of governmental machinery, a denial of stay too was justified. What if Justice Krishnaiyer had said no stay? They would have had to choose another leader. And they would not have the guts to pass a 39th Amendment with that kind of a parliament. Now look at this. Add to this list. No ragtag coalition of opportunists that collapsed by 1979, giving Mrs. Gandhi the chance to come back with a 353 seat majority. Now, 352 plus 1. Again start controlling appointments to judiciary. But a few good things might also not happen, namely the 42nd Amendment introducing 39A to the Constitution, and the so-called atonement of Justice Bhagwati, Justice Krishna, and to some extent, but Justice Chandrachud, which gave rise to the PIL movement. So in the book that's come out, which is edited by me, we have an interview with Professor Upendra Bakshi. So one of the questions I asked him is this: do you subscribe to the view that this was a move atoning for the sins of the Supreme Court? And Professor Bakshi seems to agree that the launch of PIL with these two judges at the helm, Justice Krishna and Bhagwati, was perhaps because they were atoning for what had happened in ADM Jabalpur. Bhopal gas disaster. I don't know if I have time. So basically what I'm saying is this. On the intervening night of 2nd, 3rd December, lethal MIC gas leaked in Bhopal. It was said more than 3,000 persons died. Actually, more than 5,000 persons died. The normal thing to do, which is what the Indian government did, was to go to the US courts, because the Union Carbide has its headquarters in the US. Go to the court there and seek relief for damages. Obviously, a mass tort, because by then it was clear that a failed technology was being deployed by Union Carbide Corporation in India without any disclosure to the neighborhoods. And this plant was located in a very, very crowded neighborhood, and there was no emergency drill. There was no emergency disaster plan. So people didn't know that they were not supposed to run out into the streets, because many of them ran out into the streets, more people died. So it's a very serious matter. Of all people, the celebrated Mr. Nani Palkiwala gives an expert opinion in the US court, where, and I have to quote this. This is what he says: the ends of justice often require the truth to be faced squarely and stated bluntly. Indian courts are inadequate only in the sense that they are inadequate instrument for procuring the fabulous damages which American juries are prone to award. Since this affidavit is only confined to the Indian legal system, I shall make no submission on the question whether forum shopping should be permitted. So he terms this going to the US court as forum shopping, as a means of virtually getting American aid thinly disguised as damages. And Mr. Palkiwala extolled on the virtues of the Indian legal system, saying they're perfectly capable of handling, these kind of cases. It is possible. I'm not saying it's possible, because there were certain other factors that weighed with Judge Keenan of the New York Southern District Court in deploying the phrase forum non-convenience to say you go back to the Indian courts to pursue your remedies. It is possible that he may not have sent the case back to India. It is possible if the case had remained in the US, if a settlement had been arrived at, it would have been a much, much higher sum than the $470 million US, which in 2023, the government of India was telling the Indian Supreme Court was based on gross underestimates. They had underestimated the number of dead, they had underestimated the number of injured, which ran to lakhs of persons. In between, something happened which precipitated the settlement of February 13, 14, 1989. Even while the settlement was happening, the government of India was lobbying for the appointment of Chief Justice of India, R.S. Pathak, to the International Court of Justice. This is written about by Mr. Gobind Das in his book, Supreme Court in Quest of an Identity. The court was told, it was a huge outcry, saying, how come the victims are not heard? Union of India, UCC have got together and arrived at a settlement. Then the court comes out with what is called an explanatory order. Doesn't convince anyone. They say, how can you close criminal cases? What they did in the settlement was to say 470 million is adequate for the damages. They also closed all the criminal cases, which included charges which are clearly non-compoundable. At that point in time, it was 304 Part 2. Later, it got diluted to 304 Capital A. The fact remained that by way of a settlement, you were closing non-compoundable criminal cases. So very reluctantly, in May 1991, a 5-judge bench of the Supreme Court says, no, we will not reopen the settled claims on the civil side, but the criminal cases can go on. What happened as a result? Warren Anderson, who had been given a special chartered plane by the then Chief Minister of Madhya Pradesh to leave the country, he had come to visit the plant. He quickly made his escape, could never be extradited. He never faced trial. UCC was taken over by Dow Chemicals. UCC disappeared. Dow Chemicals said we only took over their assets, we didn't take over their liabilities. In the criminal trial on a diluted charge, only the Indian accused got convicted, but their convictions were stayed by a sessions court. And as I speak to you today, 2025, 41 years after the event, that stay continues. Nobody has gone to jail for the 5,000 people and lakhs of people injured, 5,000 dead persons and lakhs of people injured in Bhopal. So, but for the settlement, see, what if the settlement had not happened? One is we lost a golden opportunity for developing a rigorous tort law principle, namely of strict liability. Justice Bhagwati had planted the seeds of this in the oleum gas leak case, hoping that later benches of the Supreme Court would pick it up. That never happened. We still have foreign technologies being deployed in this country which have failed elsewhere. We have a very weak regime of corporate criminal liability in this country. So those opportunities of actually developing the law were completely given a go by. I'll quickly refer to some other what-if cases. One is, of course, the famous Babri Masjid, Ram Janmabhoomi. I've spoken about it in other fora. I still maintain that that demolition, which was declared by the Supreme Court of India to be a criminal act, not in one place, but 3 or 4 places in its 2019 judgment, that criminal act could have easily been foreseen. And the Supreme Court, this is my understanding, the Supreme Court could have prevented that unlawful demolition of the Babri Masjid. You know that one event caused riots all over the country. Thousands of people have died in many cities in this country. And those consequences of that one criminal act, we are still facing. So this is one which is bristling with all the what-if moments, but I can't devote a whole lecture just to that at this point in time. But this is certain, many days of civil unrest and a permanent damage to the fabric of communal harmony, that could have been averted had we had a more alert Supreme Court that could have prevented the demolition of the Babri Masjid. Then we have the Sahara Birla Diaries. This was a raid conducted by the Income Tax Department on major industrial houses. A settlement was arrived at before the Income Tax Settlement Commission. They seized diaries of contributions to political parties of important personages in political parties. The Income Tax Department, before the Settlement Commission, protested against the settlement. So this whole petition that was presented was based on these hard facts. But the Supreme Court said, no, this is not enough. These are some loose sheets and diaries. We're not going to act on it. And let it go. Again, the Rafale matter, notings on the files were made public by the Hindu national newspaper. The Supreme Court said it's already in the public domain. They did not allow the government to claim privilege. Yet in the review petitions, they say that these are matters of national security. The best decision has been taken. So not even asking the investigating agency, what are you doing about this? They were not even prepared to do that. It is my understanding that if these cases had been decided differently, the political course of the country would have definitely been impacted. People often ask me, when you say what if, do you think we would have had something better? I keep telling them I don't know about better. I can only say it would have been different. How different it may have been is for anybody's guess. But it would not be what it is today. Because these are very, very important moments. I keep the Rafale and Sahara cases on one side. I keep the 2G telecom scam and the coal scam on the other. Look at the approaches of the court. Completely different. There they're saying we'll monitor the investigation. We will monitor the trial. We'll make sure that no order of that trial court is challenged before any high court in the country. Every challenge has to come only to the Supreme Court. They're so carefully micromanaging the 2G coal scam cases for what? For acquittal. At the end of that whole exercise, there's acquittal of everyone. Now, in this, there's not even that first move to say, what are you doing as law enforcement agencies, investigating agencies? This is not material enough. Now, on the administration side, and this is the interesting part. You know that in 1993, we changed the system of appointment of judges to the constitutional courts. By an interpretative innovation, they said the word consultation in Article 124 of the Constitution should be read as concurrence. Basically what it meant was, till then, the executive government was having the primacy the last word in appointment of judges to constitutional courts, it had on paper to consult the Chief Justice of India. It need not be concurred with by the Chief Justice of India. Now they said, no, independence of judiciary. We can't have an executive government take over this whole process. The Chief Justice of India will have the last word. So we will say it's not enough to simply consult, but there must be concurrence of the Chief Justice of India. Then they hitched this in with some more precautions. They said it will not be an individual CJI who will take a decision. He or she will sit with two of the senior-most colleagues in the Supreme Court when it comes to appointments to the High Court or Chief Justice of the High Courts, or sit with four of the senior-most colleagues if it's about transfers of High Court judges or appointments to the Supreme Court. The expectation was somehow the arbitrariness will be less, transparency will be more, accountability will be more, and we'll have a more independent judiciary. I think the person chairing today's session will disagree with each of these, and he has said so in his dissent in the NJAC judgment. The working of the collegium has been very disappointing on all these fronts. Yes. So they struck down, when that opportunity arose, to have a National Judicial Appointments Commission. It was struck down by a 4:1 majority, with Justice J.Chelameswar dissenting, saying that it is impacting on the independence of judiciary. But as we know now, the working of the collegium system, those so-called objectives have not been met. I'm now going to give you examples on choice of judges, both in the pre-collegium period, that is pre-1993 and post-1993. I've already told you how it's entirely possible that Justice Krishna need not have come to the Supreme Court, right? Because of the supersession of Sheleth, Hegde and Grover, and because of the supersession in 1976 of Justice Khanna, Justice Chandrachud was junior to all of them, the senior Chandrachud, suddenly found that he's on top of the ladder. So he got a term of 7.5 years as Chief Justice of India. I don't think that's going to be repeated hereafter. And that happened why? Because the Janta government said, we will go by principle. We will only follow seniority. So it actually helped Justice Chandrachud, the senior Chandrachud, to not be deprived of his CJI-ship. But this problem didn't start only then. When the very first Chief Justice of India, Justice Kania, died, the next in line was Justice Patanjali Shastri. Pandit Nehru wanted to bring M.C. Chagla as Chief Justice of India directly. And this is 1951. Justice Chagla, if he had been brought in then as Chief Justice of India, would have been CJI for 14 years. So somebody says, no, what difference that would have made? They don't understand Indian constitutional history. It would have been very different. What might have happened will be very different because the CJI, even in the pre-collegium period, had some say, depending on how strong that personality was. And we now know that Chagla was a very strong personality. Likewise, if the government had its way in 1970, imagine Mr. Mohan Kumar Mangalam becoming the CJI. He was just 54 years old then. Had Justice P.N. Bhagwati been sworn in earlier, he would have wiped out Justice Chandrachud altogether. Justice Chandrachud, who got 7.5 years, would have not become CJI at all. The arbitrariness surrounding who should be sworn in first has persisted both in the pre-collegium and the collegium systems of appointment. What makes it fascinating is these are deliberate, calculated choices. They're not mere accidents. There was a period of time when there are accidents. What are kind of accidents I'm talking of? When Justice Pathak goes to the ICJ, Justice Venkatramaya becomes CJI. Justice Venkatramaya was not in line for CJI-ship at all. Justice Mukherjee dies while in office. Justice Rangnath Mishra becomes CJI. He was not in line for CJI-ship. So these are accidents. But the other examples I'm giving you are not accidents. They are deliberate choices. For instance, swearing in Justice Ahmadi before Justice Kuldeep Singh. Both are to be sworn on the same day. Somewhere someone is deciding, okay, swear in Justice Ahmadi, then swear in Justice Kuldeep Singh. Justice Kuldeep Singh was furious. He kept asking till the date of his retirement, on what basis did you decide that I should come next? So they said some explanation they gave him, that Justice Ahmadi is from the judiciary itself. you are directly from the bar. There was no such rule. There was no such rule, but they just produced a rule. When the person asked, why this? Then I can tell you one more thing, and I might embarrass him a bit. Justice Gogoi was junior to Justice Lokur in the Guwahati High Court. In the Guwahati High Court, when Justice Lokur went as CJ, Justice Gogoi was J1. No. No. So it's entirely possible that Lokur could have got sworn in earlier than Gogoi. Entirely possible that Justice J.Chelameswar could have got sworn in before Justice Deepak Mishra. Am I right? Entirely possible. Justice Bobde was sworn in before Justice Arun Mishra. That's right. So Justice D.Y. Chandrachud is sworn in before Justice Kaul, Justice Sanjay Kaul. What I'm saying is this, you may not understand this. At the level of the High Court Chief Justices, and picking up for Supreme Court from them, among them, either they should say, we'll follow seniority list of Chief Justiceships. They don't follow that. There are numerous examples when they don't follow. They should say, okay, we follow all India seniority list. Of course they don't follow it. So there's no rule. And even if you read those resolutions, they won't tell you why is Justice Sanjeev Khanna being taken directly to the Supreme Court. I mean, it's a good happenstance that his period of CJI-ship is something that I see as an observer far more redeeming than many of the other CJI-ships. At least he made the whole appointment process transparent and stopped the Places of Worship Act spreading like a hydra-headed monster. But that apart, we don't have answers for these things. We don't know what is that is weighing with the collegium. We have what is called the succession plan, right? As a CJI today, I want to appoint few CJIs. There is some big thing about this. How many CJIs have you appointed? You appointed 2, you've appointed 3. I've appointed 3, brother. It's a big thing. You're determining the future. Today, when the collegium chose who will be the CJI in 2033, they're deciding for 8 years hence. On what criteria did you pick up a person who's 52 in the seniority list? On what criteria did you pick up a person who's, there are numerous examples. Justice Lahoti comes straight to the Supreme Court. Not a Chief Justice of any other court. Justice Sadashivam comes straight to the Supreme Court. There are numerous such examples. Justice K.V. Vishwanathan, his name is proposed in a certain collegium, headed by Justice Lalit. One of the members of the collegium says, I'm holding court till 9 in the night. I will not come to participate. The collegium is waiting. Doesn't participate. The same gentleman, when he becomes CJI, appoints Justice Vishwanathan. Justice Vishwanathan, as a result, is now getting some months as CJI. Had he come 2 years earlier, much longer as CJI. So what I'm saying is there is an arbitrariness to all of this. So we don't pause to ask, let me give you one more last example, because people don't understand what is that collegium does. I have 5 names, recommendations from the High Court of Kerala. I have another 8 names from the High Court of Alladi. The Kerala names have reached the Supreme Court in January 2025. The Allahabad names have reached in June 2025. If you are the collegium, what will you do? You should pick up the Kerala names first. I am the Chief Justice of India. I have to convene the collegium meeting. I will pick up the Allahabad names. Why? Nobody knows. Those recommendations sent, those judges are appointed. Kerala judges have been waiting since January. That's why it's so useful to have a chair like this.
53 names for 5 high courts were cleared by the collegium, of which I was a member in 2017. 1 high court was Chandigarh. 1 high court was Patna. 1 high court was, I don't really recollect, 1 high court was the old Andhra Pradesh High Court. 53 names were cleared. The Patna High Court was cleared first. Within a week, the list came out. It happened to be the then Law Minister's home state, home High Court, parent High Court. Then the Chandigarh High Court was cleared because it happened to be the Chief Justice of India's parent High Court and one or two other High Courts.
I must also add, the idea of saying all this is to provoke.
I know, I understand.
See, you won't get this information RTI.
Why then Andhra Pradesh was held back. You could still get it now. I wrote a letter to the Chief Justice. Andhra Pradesh was held back for whatever reasons, anyway, I don't want to now disturb. This is what happens.
Thank you, sir. Thank you so much. Now you have an added factor, central government. I sent A, B, C, D, 1, 2, 3, 4. Central government doesn't tell me as a Supreme Court collegium what it is. Central government issues warrant for number 3 first. Number 1 some 3 months later. Why? Nobody knows. Does it matter? Of course it matters. Because the All India seniority matters, your chance to become Chief Justice matters, your therefore chance to Supreme Court matters. So for people watching all of this, they may say, what's the big deal? What is so much about this 1, 2, 3, 4? It is. And for the person who knows he was supposed to be top of the list, now he's suddenly at the bottom of the list, he's wondering, why did I consent? No principle. See, there's no principle involved, there's no law involved here. Which is the what if? Now, to some of the lighter moments of this lecture. What do we make of all this? I've been saying so many things. One is that judges are political actors. And they make political choices. An apolitical judge is a myth. Apart from the stay granted by Krishna Iyer in June 75 in the election case, there have been numerous occasions when different benches of the Supreme Court of India have made choices that are political. When they approved the dissolution of all the state governments in 1977, they were making a political choice. In S.R. Bommai, when they decide so many years later that the dismissal of certain governments was right, they were making a political choice. In the B.R. Kapoor case, Jayalalitha is elected by a popular mandate, but really the law disqualifies her. She's been convicted in a corruption case, despite which the governor of that time swears her in. It required 5 judges to say, nothing doing. Don't make a mockery of the Constitution. They unseat her. The 5 judges sit and unseat her. But the same Supreme Court delays the pronouncement of judgment in her subsequent corruption case, allowing her to continue as Chief Minister. How can you say these are not political choices? Of course they are political choices. Advancing the date of the floor test. Postponing the date of the floor test. Political choices. Interfering with the decision of the Speaker, not interfering with the decision of the Speaker, interfering with the decision of the Governor, not interfering, all political choices. So that whole anti-defection law, if you see how it has been dealt with the Supreme Court, you will realize how they have allowed certain governments to take over, how they've actually legitimized horse trading in politics, but somebody has to do that deep research. Students here should pick up the 10 schedule cases for understanding what political role the institution plays. Professor Bakshi, and this is a judge-centric Supreme Court we have. You go before this bench, certain things will happen. The same case you take to the next bench, something else will happen. So as lawyers in this room will understand, when the client comes and he brings out the case, we draft the petition, we get it numbered, you go to a senior, first thing he'll ask, before whom is it coming? Very natural question. Why? We understand. Some judges will do this, some judges will definitely not do that. All right. Professor Bakshi says if justices have such vast power, the question is how self-conscious they ought to be to use that power. And Bakshi says this, it is my contention that they ought to be fully self-conscious. That is, they ought to acknowledge full responsibility for political choices. He adds, he says, the question is, what kind of politics ought the court to engage in, and not whether it should engage it at all. Justice Bhagwati says this in the dissolution cases. Because one of the questions is, they're all political questions. He says, every constitutional question concerns the allocation and exercise of governmental power, and no constitutional question can therefore fail to be political. A constitution is a matter of the purest politics, a structure of power, and as pointed out by Charles Black in 80 Perspectives in constitutional law symbolizes an intersection of law and politics, wherein issues of political power are acted upon by persons trained in the legal tradition, working in judicial institutions, following the procedures of law, thinking as lawyers think. We have now reached a point when politicians are becoming judges of the High Court. Right? You have the General Secretary of the BJP Mahila Morcha. You have the speaker, spokesperson of the BJP till 2023 becoming a judge of the High Court. And then you have the other process. Sitting judges become politicians. I resign as judge of the Calcutta High Court. Within 3 days, I'm given ticket to the Lok Sabha in Calcutta. And I win with a thumping majority.
Well, I don't agree with you. If Warren could become a good chief justice after being the governor, there's something wrong with the because what they write is more important.
Well, sir, in a more informed court with better checks and balances, where Warren will not be holding a bench of 1 or 2 judges, it's still acceptable, but not in our kind of a system. We just cannot, and we have to be transparent. See, we actively keep out certain politics from our courts. And we encourage certain politics in our courts. And there is no cooling off period. The judge resigned today and day after tomorrow he's actively campaigning, sir, on the ticket. How is that acceptable? Sir, I beg to differ from you. That is simply not acceptable. There has to be a cooling off period. He may be interested in politics. He can't become a politician. How are we supposed to believe when within 3 days he's campaigning for BJP vociferously that just the last week when he was sitting as a judge in the Calcutta High Court, he was completely neutral, completely impartial. This is why the justice seeing to be done is so important. That is a very, very useful measure for us to view these things. Baharul Islam, for instance, resigned as a Supreme Court judge to contest on a Congress ticket. Hanumantappa, I think Justice Hanumantappa, you should know, was a member of the Lok Sabha contesting on Congress tickets. He was a Chief Justice of a High Court. Of course, there have been appointments of very wise people to the Rajya Sabha, and even wiser people as governors. And they're expected to believe they've all shed any trace of impartiality. They're all totally objective. They're great statespersons. It's difficult. It's very difficult to accept that these are not political persons making political choices. One principle that I pick up, yesterday's dissent is today's law. I call it the I told you so moments. So Justice Fazal Ali could very well say from his grave, I told you so. This is how you're supposed to read part 3. Justice Vivian Bose will tell you in many cases. He said, what are these people? That second principle of Justice Einstein, not Justice Einstein, Alfred Einstein. It was so plain for me to read. You guys were not reading it. Justice Learned Hand, and you like this, sir, is supposed to have once said that judges take oath to preserve and protect the Constitution, not an oath to preserve and protect the predecessor's interpretation of the Constitution. There are some dissents which cannot become good law. I spoke of Justice Venkatachalaya's dissent in Antule. It just remains a brilliant dissent. Justice Nagaratna's dissent in the demonetization case. It will simply remain a good dissent. It doesn't change the course of history as far as demonetization is concerned. Justice D.Y. Chandrachud's dissent in the Romila Thapar, Bhima Koregaon case. Very good dissent, but will not change what is happening in those cases. One dissent that still gives hope is D.Y. Chandrachud's dissent in the Aadhaar case. You know, I think Professor Uma mentioned what Justice J.Chelameswar being part of the privacy judgment. Do you know that they excluded him from the bench that decided the Aadhaar case? They excluded Justice Bobde from deciding the Aadhaar case. If you ask him why was he excluded, he might tell you in a private conversation. But these are choices. Somebody is making these choices. Why was that Aadhaar case decided by a 4:1 majority, upholding the whole Aadhaar thing on a very specious ground? They accepted that it could be a money bill. That money bill question is pending before a larger bench. What if that larger bench, some 5 years down the line, says this kind of a act can never be a money bill? Are you going to be undoing all of it? How can you unscramble a scrambled egg, right? So this is a serious question we have to ask. What if Justice J.Chelameswar had sat on the Aadhaar bench? What if Justice Bobde had sat? They were the judges. Justice Bobde was the judge whose bench referred the matter to the, and you, sir, correct? That's what. That's right. None of you were there when the Aadhaar case. No, privacy you were there, sir, but not in the final Aadhaar. But Bobde was there. So these are questions that we have no answers for. So then it boils down to this: fait accompli and delays. Why is the Article 370 case decided so late? Why is the electoral bonds case decided so late? What do you do in electoral bonds? We were very surprised. Wow, Supreme Court has actually said electoral bonds is illegal. Then comes that other line: nobody need return any of the monies. Billy chua kaake haj par chali gayi. So this are difficult. I mean, we don't understand what is happening. You've not taken up the Pegasus case. It has huge ramifications. You've used a spyware manufactured by an Israeli agency to spy on a range of journalists, opposition leaders, and even Supreme Court judges. And this doesn't engage the Supreme Court. You've appointed a committee. The committee has given its report. That's it. It's gone into a black hole. When will it be taken up? When it is taken up, what will you decide? Will you say, it's all over? What's the point, sir? Because I say so, there are those judgments. L. Chandrakumar, how do you rewrite the Constitution? Okay, 226, High Court's judicial power, basic structure, all fine. You know, this direct appeal to the Supreme Court, SLP. Too much work, brother. Let's push it to the High Courts. Till date, it's a 1985 Act, Administrative Tribunals Act, no amendment. No amendment in the Constitution. But all decisions of Central Administrative Tribunal have to go to a division bench of the High Court. How? Article 142. Babri Masjid. People don't realize the entire operative portion is 142. It rests on that Article 142. Recent phenomena of intra-court appeals. A division bench, Justice J.Chelameswar will have strong views on this. Division bench passes an order. Mention is made before the Chief Justice. He constitutes a different bench, which stays the order of another bench of the Supreme Court. Unheard of. There's nothing called an intra-court appeal at the Supreme Court. How is it justified? Article 142. Jurisprudence of remorse. I say sorry. So one judge in the NJC case, I have not named, said, I'm sorry. Collegium system I also watched. I agree with Justice J.Chelameswar what he's saying. I should not have signed with the majority. Justice Bhagwati, at 89th year, 2011, he's interviewed. He says the Supreme Court should be ashamed about the ADM Jabalpur judgment. I plead guilty. I don't know why I yielded. Justice J.S. Verma, the Hindutva judgment, his daughter says he regretted about how he was being misunderstood after that judgment. And a group of politicians had twisted the spirit of his judgment. Then you have judges, they start expunging those extrajudicial remarks they make because of media outcry, public outcry. You have the category of Operation Successful, Patient Dead. It happens in all those cases of prospective overruling. The poor Ramzan Khan, he went all the way to the Supreme Court to say, sir, before giving me penalty, you have to hear me again. You have to give me a report of the disciplinary inquiry. You have to hear me on punishment. They said, yes, correct. You're absolutely correct. That is the law hereafter, but not for you. So his operation was successful, but Ramzan Khan died. Electoral bonds is another thing I've said. Then you have what are called the Madurai Veeran moments. Justice Raghuram will enjoy this. You know, we had Mr. N.T. Ramarao, of course, But his inspiration was Mr. M.G. Ramachandran. These are the only two characters who could translate cinematic popularity into political popularity. So MGR was so popular that in MGR's films, MGR cannot die. So this was a historical movie on Madurai Veeran. Why is he called a Veeran? Because on the battlefield with his chest exposed, he's dying. So last scene had to be Madurai Veeran getting killed. When that was first shown in the Madras, there's a Chitra talkies. The talkies got burnt down. So I called it the Madurai Veeran ending. So they had to change the ending. When finally Madurai Veeran is getting slashed, he rises with garlands. And there's huge applause in the cinema hall. So Supreme Court will give a judgment. People will protest. They'll say, let's change the ending. Sabarimala, no, how can you stop women between 10 and 55 entering Sabarimala? Huge outcry. Let's change the ending. How will you change the ending? Wait for those judges to retire. Take up review petition. Sit with different set of judges. Say we'll refer it to 7 judges. Ending changed. Anuradha Bhasin, very progressive judgment. Right to internet is free, part of fundamental right. Great judgment. You go back in 2 months, sir, none of your directions is being followed. I say, keep quiet. The judges are saying, telling the petitioner, keep quiet, national security. But sir, you have only said that they're supposed to disclose reasons for why they're continuing to block the internet. No, we'll see. After the third time, matters not even listed. Ending changed. So wonderful judgment, ending changed. Then judicial dice, judicial lottery. Death penalty cases, literally the choice is between life and death. There are judges who will never confirm a death penalty. There are judges saying, bring. I'm waiting to confirm. Not only confirm, I'm waiting to enhance. So as lawyers, we know which are those benches. Yaar, mar gaye hain. Literally mar gaye hain. Because the other bench is going to have a different philosophy. They will talk of punishment, reformation, rehabilitation, probation officer, all of that. This judge will say, cry of society, we need a strong law. We need to send a message out. Completely different philosophies. Here I'm not arguing one philosophy is right, the other is wrong. But I'm saying, look at the difference. And how uneven and how arbitrary the whole thing can be. And who will decide? Chief Justice of India decides. Roster kiska banwana hai? Who should hear these cases? So it's a huge power. Then you have this mirror on the wall. Judicial egos and judicial vanity. It's a big problem. So you will always have instances, and lawyers here will know, where the Chief Justice, whether of India or of High Court, will loggerheads with this next senior most. Will not see eye to eye. Some will say nothing. If you say A, I'll say B. So you can frustrate the working for months on end. And now nothing comes out of it. Mr. Gadboy's book, which is J.Chelameswar must have read, lists out all those instances, not just post 1993, but even pre 1993, where Chief Justice of India and his next senior most have been at complete loggerheads. Judicial vanity. So you had a judge of the Supreme Court, and you had this lawyer who was a dear friend of mine, who would argue preventive detention cases. So he found a nice technique. My Lord will see 1982 Calcutta, page 412. When my Lord was in the High Court. Yes, my Lord, what a lucid exposition. You know, so many judgments of the Supreme Court have been rendered after that, but nothing matches this. So first ball is bowled. Then, my Lord, 1987 Calcutta, when my Lord was sitting in the division bench. Acha, my Lord, you have developed on the law. You know, I have actually had foreign judgments which are quoting your Lordship. Is that so? Then, my Lord, 1989 Calcutta, just before your Lordship came to the Supreme Court. So he says, Mr. Counsel, how come you have done such wonderful research? So counsel is saying, my Lord, before my Lord, it's very simple. Before my Lord, I only cite my Lord's judgments. Vanity. Vanity can operate in reverse. This is what Justice Raghuram calls Navagraha syndrome. Before Surya, never quote Shanishwara's judgments. They're at loggerheads. Acha, this is what this judge has said. I have to somehow reverse this now. So some lawyers, after the judge leaves, a new judge comes, who's in this Navagraha syndrome, they will keep back all those judgments. Yaar, isko to dikhao na mat. Keep quiet. Don't show this judgment. It happens. See, judges are human beings. So lawyers, you have to strategize. You have to know which judge will accept which judgment. Then my Lord performs divine function. Many judges actually feel, one judge told the senior lawyer, Mr. Counsel, when you keep saying, my Lord, my Lord, my Lord, it's as if my Lord has entered into me. It's a serious problem. The minute you start taking it seriously, see, as judge, my wife Usha says, acquired helplessness. You can't open your own door. You can't carry your own paper. Even entering lift, you have to do by seniority. So serious problem. Then suddenly one day you're retired, you're back at home. Nobody's going to do all this. So one of the Delhi High Court judges, she was telling me she was visiting abroad, her sister-in-law. And the car came and halted at the door. And she's sitting in the car. And the sister-in-law came and said, Babiji, here you have to open your own door. Becomes a habit. And then personal prejudices. If you are at loggerheads in the High Court, when it's your turn comes to the Supreme Court, and your loggerhead persons are sitting in the Supreme Court, finished, you don't get into the High Court, into the Supreme Court. One judge lost out. He had to wait for 2 of his compatriots from the High Court to retire before his name could be taken up, and he got hardly 4 years. I know he knows whom I'm referring to. A brilliant judge. Personal prejudices. In undivided Andhra, I'm told at one point in time the judiciary, nothing was tailor-made. It was only ready-made. And at another point in time, I'm told there were no full stops, only commas. So, you have these changes. You can see those changes, that those prejudices come to the fore. And only people who watch the system from within the system will know what informed this choice. A lay person will not know. A lay person will be thinking, oh, there's some procedure, there's some criteria. I'm not saying there's no criteria at all. Let me not be mistaken. But when you have to choose between people, let's say you satisfy a certain criteria, then you have to choose A, B, C. That must be disclosed. It can't hinge on this kind of an undisclosed prejudice that you have in your mind, which you cannot overcome. If I'm born a comma, how can I change that, right? I can't change that. There are I agree judges. You think division bench, both are strong? No, one judge will dominate. You see this day in and day out. So you have what are called I agree judges. Anything senior judge says, I agree. So in Patna High Court, they told a judge, who was an I agree judge, yeah, you're retiring in another 3 months. You've sat in the court for 3 years. There's not one reported judgment from you. At least take a stand. Why do you have to agree every time? So the next time a draft was sent by the senior judge, this man wrote, I disagree. So the senior judge called him. He says, brother, good thing that you have done. But can you give me the reasons why you disagree? He says, they didn't tell me that I'm supposed to give reasons. Struck it off and said, I agree. So, you think it's a division bench. It's not a division bench. One person is, and then you have meaningless platitudes, protocols, and what we call propitiation. This has happened because of the collegium system. You think that going from High Court to Supreme Court is kind of a promotion. You have to be in the good books of Supreme Court judges. Most importantly, of your judge in the Supreme Court, from your state. Usko jaake every now and then you have to say pranam. And Justice Raghuram, I'm going to now use his name. He says, they're all deities. So he says, you're standing before Lord Ganesha. You cannot chant Hanuman Chalisa. You have to chant Ganesha Stotra. So we've elevated all these personalities into, deities. And we begin to propitiate. It's because it's human nature. How do we break these hierarchies? We have to break. The more we say, what if we had not put all these people on a pedestal? You will say, okay, let's dismantle the collegium system, but what will you have in its place? You will start propitiating political masters, because that's human nature. Are we able to overcome all this? Are we able to just see, what we are expected to do? Ultimately, it boils down to the need for greater accountability and transparency. We need to know why judges behave the way they do. We need them to be aware of their fallibilities and foibles and not just of their predecessors. I'll end with Cardozo's quote. He says, there is in each of us, he's talking of judges gently, there is in each of us a stream of tendency, whether you choose to call it philosophy or not, which gives coherence and direction to the thought and action. Judges cannot escape that current any more than mortals. All their lives, forces which they do not recognize and cannot name have been tugging at them. Inherited instincts, traditional beliefs, acquired convictions. The resultant is an outlook on life, a conception of social needs, a sense, in James' phrase, of the total push and pressure of the cosmos, which, when reasons are nicely balanced, must determine where the choice shall fall. I'll just end with one funny episode. My lord is a great believer in numerology. Some astrologer told him, sir, number 7 is very good for you. So he told his court master, in my court, there should be 61 matters, or 52 matters, or 43 matters. Why total into 7? If it is not true, it will be funnier. It's absolutely true. Then lawyers found a way out. They would go to the court martyr and persuade him in the way best known to them to add 51A, 51B, 51C. This judge was transferred from the main bench to the, not circuit bench, let's say another bench of the High Court. There he found some other judges sitting in court 7. So he sends his PS to the PS of that other judge. So in Tamil he says, Sir to solli konjam adjust panna solunga. Which means just ask sir to adjust a bit so that my sir can sit in court 7. So the judge who sits in court 7 has heard this. He calls the PS. He says, tell your sir, there is a board saying 7 outside my court. He can lift it and put it outside his court. Thank you so much.
Now, the next item is the speaker will take a few questions. But I think Uma, we must fix some time. 20 minutes? In a period of 20 minutes, a few questions will be taken. Anybody interested in asking a question may kindly raise the hand. You want to ask?
I want to say something in response to you, if I may. What if we didn't have lectures? What do lectures do? I think Muralidhar Garu has answered it more adequately than ever. Thank you, Muralidhar Garu, for that. If we didn't have lectures, we wouldn't have such an engrossed audience, which will go back with a lot of questions. And that's what a university should do, let the mind ask questions. Thank you so much. Sorry I intervened.
I think,
Yes.
oh,
Again, stand up.
please, please, please.
Yeah, I'd love to hear your thoughts on. Yeah.
Let's talk about the issue of reservations, right? So how you compose the bench, then here's a question concerning reservations, right? You might say, no, all judges of Supreme Court are as good as every judge of the Supreme Court. So it doesn't matter if representatives of those categories in the court. You must, as a CJI, have very good reasons to exclude them from the bench. So you find that this is a serious issue. You know, there was a judgment, there's a case where they had to consider overruling Hanif Qureshi case. All right. Hanif Qureshi on cow slaughter ban in Bihar, 1955, I think, where they said we'll uphold the ban on milk producing cows, not across the board. Gujarat said every and any cattle, nothing should be touched. So that was challenged by the Buffalo Meat Traders Association. Now, how do you constitute the bench? It's a 7-judge bench. In that 7-judge bench, 6 are vegetarians. You have a serious issue here. I can't say as CJI, no, for me, every sister, every brother is the same. You can't say that. Questions will be asked because we need a representative court. Aren't we arguing that, listen, Dalits are underrepresented, women are underrepresented, minorities are underrepresented. You therefore have to be very, very conscious and careful because you're performing a public function. And you must give confidence to the people who have their cases and causes before the court that, this is a fair decision. And many things can impact the fairness. At the end of the day, let's say you had a most representative bench which came to the same conclusion. But at least it will not meet this kind of a criticism, right? So that master of the roster and, who should come onto a bench are very, very vital and important questions for the future of the country also. So that needs to be constantly critiqued, interrogated.
Good evening, sir. Sir, the topic of the today's discussion is different yesterdays for different tomorrows. Sir, in between the different yesterdays and different tomorrow, there comes the different todays. And todays are marked with a kind of suppression where the people are lacking some insight, they are lack some courage to ask the question to the government because the suppression level is very high. And even there is a very big gap and difference between constitution and constitutionalism, as there is a serious attack and successive attack on the constitution. Then the justice has been a far cry.
All these are your comments. You have to come to your question.
Sir, my question is, what should be done to lessen the very idea that justice can be served to all, irrespective of their differences, and what can we
see? It can only be a work in progress. I think you missed out one line. No system is ideal. You have to engage with it. You have to study it. You have to look back in history. It's not that this today is happening only now. It happened earlier in history. There were people who had solutions to that, in sometimes violent ways and sometimes non-violent ways. People have expressed their view, they throw out a government, they bring in a new government, right? So there are various ways of meeting these challenges. History will tell you how you overcome that, right? How do you bring about awareness? How do you question those in power? How do you use the constitution to develop arguments to question that power? The constitution has enough provisions to put a check on abuse of power. How you use them, how you strategize on how you will bring an issue to the court or how you will take it to the public. These are all in your hands. So be an informed, vigilant citizen who is not afraid of engaging with difficult issues because today it seems very oppressive. Keep reading, keep talking, keep discussing, becoming part of that public opinion generating public. Even today on the net, where you have a lot of hate speech and trolls and all that, you will find some sane voices. If you ask Justice Raghuram which channels he watches, he'll tell you, and which channels he doesn't watch. Then if somebody like Justice Raghuram is watching that, you'll say there must be something right about it, correct? It's like that.
Thank you, sir. Thank you very much.
Yes?
Yes, sir.
Thank you, sir, for sharing your thoughts. Have you ever thought, what if you were to go up to the Supreme Court and what if you were to become the Chief Justice of India? Did you have any thoughts, ideas as what you would have done?
No, I never saw myself like that at all. I knew every day as a judge, I must decide the case that comes before me to the best of my ability.
Then I'll ask
That's the best frame of mind to be in.
Sir, I'll ask the same question of Justice J.Chelameswar then.
What is the question? I didn't hear the question. What is the question anyway?
What if you were sworn in before Justice Deepak Mishra? You would have become the Chief Justice of India. So
See,
did you at that point in time have any...
Long back I read, Bertrand Russell said somewhere, in old Greece, people were elected by lottery, I believe. And Russell commented, occasionally the lottery fell favorably to the people. It so happened it fell favorably to this country that I didn't become the Chief Justice. That's all I can say.
Thank you, sir.
See, let me also add, once you're in a system like this, if you watch the system long enough, you should not be surprised about all these kind of decisions. You should not stop talking about it, but equally you should not be surprised, because you should still continue to function as a judge. That is your primary purpose of being in that system. All right. Yes.
I think we can stop here. Thank you, brother. And now, Uma. No, one. Then, Ms. Sridhar, where are you? What up?
I have the pleasant duty of proposing the vote of thanks. Since a lot of the talk has been on lighter moments, I must say that I'll share with you an email that I had. I won't disclose the name because I had not asked permission of the person who wrote this. Thank you very much for sharing the invite, and perhaps more importantly, for bringing two prominent jurists who stood the test of times. Now, we have witnessed here what happens if you have two people of equal eminence and competence as chair and speaker. What was to have happened as a lecture has become a dialogue with frequent interventions from the chair, with an occasional intervention by one of the organizers, that's Uma, towards the end, of course. So this is what will happen. So maybe we have to think about what we should do next when we have a chair and a speaker. Leave the lighter moment aside. I must thank the audience for staying back till almost the very end, because perhaps this is one of the very few lectures when we had gone beyond 8 o'clock. So that talks about the power of the lecture and the topic that he has chosen, and the moment in which he chose to talk about this on this particular topic. I thank Justice J.Chelameswar for chairing this lecture and for maintaining his characteristic dissenting voice. I thank Justice Muralidhar for a highly scholarly lecture and for providing the much needed moments of humor. Justice Muralidhar, as I understand, tried to argue, I emphasize argue, that the what-if moments in Indian constitutional history are not merely of academic and scholarly interest, but that they actually matter, because certain later amendments to the Constitution, for example, would not have happened. I thank the Dean School of Social Sciences, Professor Sunita Rani, and her office personnel for their meticulous execution and for their cooperation and support. I must thank our collaboration with the Center for Human Rights earlier on, and the Department of Sociology in the School of Social Sciences, and Professor Nagaraju was here till a little while ago, and also Professor Jyotirmaya Sharma, the former Dean of the School of Social Sciences, for for their excellent support. I will be failing in my duty if I don't thank Professor Hargopal, who is joined us for being instrumental in bringing this lecture from the city to the university. And I thank the university administration, the Vice Chancellor in particular, for according permission to hold the lecture, for that has become the norm. And for the administration, especially the registrar and the authorities, for extending all support for the conduct of this lecture. I must thank all my fellow trustees of in the Alladi Memorial Trust and my advisors for choosing to bring Justice Muralidhar. I now know one of the, and again on a lighter moment, I must say Justice Muralidhar insisted that on the program sheet we do not call him Justice Muralidhar. And after the lecture, I don't have to give you the reason as to why he did not want justice preceding his name. And thank you one and all.
Hello. Sir, I am a human rights activist from Chhattisgarh. I am studying here. And my question is, first of all, thank you very much for the enlightening revelations you made. And the thing is, many a times I was tried, and on the basis of my activism, people tried to put me behind the bars, but our High Court came to my rescue and I was saved. But the disclosures, the things which you discussed with us now, it was really very scary for me and frightening even, because I was very fortunate, maybe, that I was saved by the court, but maybe suppose my case would have went to some other judge, I might not be here. I might be behind the bars. So, as a young person, what should I do? Should I really continue my journey with the activism, or should it was...
Had a first good encounter with the court, why should you discontinue anything?
No, yeah, thank you, sir.